Now, is that okay? Give me a thumbs up if you can see that okay, Ruth? Yeah, Tony, great. Right up. Super job. Okay, so good morning again. Thank you, Tony, for the Claire for the invitation to come along. My name is Damien Mulholland. I'm joined today by my colleague Ruth Tinney. So I'll rattle through the presentation. As Tony said, if you have any questions, pop them into the chat function or ask them at the end. We'll try our best to get through them all. Anything that we're not sure of or we can't answer, then certainly we'll go away and get you an answer and send it through to Tony, who can share it with the group then as well. Tony's pretty much covered the housekeeping side of things. The only extra bit I would say for you all here at the session today, Tony's also shared an evaluation with you, both a QR code for sort of quick access and an email link. So would really appreciate you just taking a minute or two. It's a very quick survey and it's important to us just to let us know what you thought of the session. And that way then hopefully for the future we can improve it as well. So I'd really appreciate if you could do that for us. So what are we really going to cover today then? Well, we're going to start by looking at some of the key aspects of pregnancy at work. And we'll move on then to look briefly at maternity leave and maternity pay as well. After that, so the sort of the main ones that everybody sort of talks about and knows about. We'll briefly touch then on shared parental leave, which is much less well known, and we'll delve a little bit then into statutory adoption leave and pay, and also a little bit on paternity leave and pay as well. And we'll finish up then by covering something called parental leave and time off for dependents as well, again, both of which are less well known. And we'll wrap it up then by taking a quick brief look at flexible working on some of the key aspects of that as well. So, okay, so I've tried to keep it as brief as possible. It's a massive area, massive topic, and so much information in this topic. So trying to cover the sort of fundamentals. We've provided you with some resources as well, which will hopefully help. And as I go through the presentation, I'll pinpoint some other places you can go for some other advisory documents and other places of contact for advice and guidance too at the end. Okay, so we'll look first of all then at pregnancy at work. And then a pregnant employee should tell their employer no later than the 15th week before their expected week of childbirth. So basically week 25 of their pregnancy, that the woman is pregnant, that the expected start date of the maternity leave and the date of the baby's birth, the intended. And it would really benefit both the employer and the employee if the pregnant woman would give that notification well in advance of week 25 of their pregnancy. And the reason for that would be really, number one, the employer would then know that the lady's entitled to time off, paid time off for antenatal care. They would know as well that particular health and safety rules then apply a little bit earlier, and they can start thinking then early stages of thinking about the arrangements needed to cover the pregnant employee while she's off on maternity leave. So employers, I would say, should encourage employees through their maternity policies, their staff handbooks, etc., to notify them as early as possible about their pregnancy, but they cannot compel them to do that because by law it only has to be the 15th week before the expected week of birth. Employers do have a legal duty to protect the health and safety of the new or expectant mum at work. And once a worker notifies the employer that she is pregnant, then the employer should review the risk assessment for her specific work area and identify any changes that might be necessary to protect her health and the health and safety of her unborn baby as well. The worker should be involved in that process, and the assessment should be reviewed as the pregnancy progresses as well, so at different stages, just to see if any further adjustments or anything are required as the pregnancy progresses. Some examples of hazards could include things like lifting and carrying heavy loads, working at heights, exposure to toxic substances, even night working potentially could be regarded as a hazard. So that's just an example. There's lots of other things. Where risks are identified, the employer should take steps then to minimize that impact on the employee. So things like maybe altering working conditions or working hours, transferring, moving the employee to maybe a suitable alternative role, or in really serious cases where the risk can't be removed or mitigated, then actually possibly suspending the pregnant woman then on full pay to protect her health and the health of her unborn baby as well. Now, an employee would be entitled to make a complaint to an industrial tribunal if there was suitable alternative work available and the employer had failed to offer her that work before suspending her. And they could also complain to a tribunal if they didn't get the right amount. An employee who doesn't take up suitable alternative work, so they refuse it, may possibly then lose her right to pay during any period of maternity suspension. So the employee would have to be quite careful there too. Now, the experts on risk assessments and advice, etc., on the health and safety side of things would be the Health and Safety Executive here in Northern Ireland. So you can get a lot more detailed information and advice from them on that. All pregnant employees as well have the right to reasonable paid time off work to attend antenatal care appointments. And part-time employees should not be pressurized to make appointments on their days off. Now, the law doesn't actually set out what reasonable time off means really regarding the time off from work. Employees must request the time off and they have a right not to be unreasonably refused that time off. Tribunals would likely find unreasonable to be a refusal of appointments based on medical advice. So if a doctor, midwife, etc. is recommending that appointment and it's refused, the likelihood is a tribunal would find that refusal unreasonable. There's no service requirement for this particular right either, so that's a day one right. And employers are entitled to ask for evidence of antenatal appointments, except in the case of the first. So the lady would have to present her appointment card, etc. And the amount of time off really will depend on the time that the appointment, I suppose, is made, the time of day. And it's not unreasonable for an employer to expect an employee to attend for the part of the day that they can attend work outside of the appointment time. The time off also includes the traveling time to that appointment. Say the lady's in working and has to travel to the hospital or to the doctors, and also the waiting time as well, and then the travel back. And employers must pay the employee her normal hourly rate of pay during that period of time off for antenatal care. A pregnant employee could potentially bring a claim of unlawful discrimination and or maybe unfair dismissal if an employer dismissed her or treated her unfairly because she tried to exercise her time off for antenatal care, or unreasonably refused her time off for antenatal care, or denied her, say, her normal rate of pay for the time off as well. Now, agency workers aren't entitled to pay time off for antenatal care until they have completed at least 12 weeks continuous employment with the same employer. And once they have completed their 12 weeks, then the agency and their employer that they're working for must allow them the time off, reasonable paid time off, to attend their antenatal appointments as well. Employees and agency workers who are in a qualifying relationship with the pregnant woman or her expected child then have the right to some unpaid time off to attend up to 2 antenatal appointments. And that time off for each appointment is capped at 6.5 hours. So it's not unlimited, so it's not. And a person in a qualifying relationship with the pregnant woman could be somebody like the father of the child, her husband, the pregnant woman's spouse, partner, or civil partner. So it could be a same-sex partnership as well. Now, we're often asked in our inquiry point or our workplace information service or our helpline about fertility treatment. The appointments for fertility treatment aren't covered, as employees must be pregnant to be entitled to the time off. So an employer isn't legally required to give an employee time off to have fertility or IVF treatment. Any time off should be treated basically in the same way as any other medical appointment. But we would recommend certainly that employers treat time off requests for fertility. And a woman who is undergoing IVF is treated as being pregnant after fertilized eggs have been implanted. And if the implantation fails, then the protected period during which the woman mustn't be treated unfavorably on the grounds of that pregnancy ends 2 weeks after. Now, pregnancy discrimination, I'll briefly touch on it. All employees, all casual workers, all agency workers are protected from pregnancy discrimination from the very first day of employment. The protection also covers recruitment decisions. So a woman is protected from pregnancy discrimination as soon as the employer knows or suspects or believes that she's pregnant, even though she hasn't told them, even though she doesn't have to tell them until the 15th week before the childbirth. For employees who are entitled to maternity leave, that protection from discrimination lasts then from the beginning of the pregnancy until the end of the additional maternity leave period. So basically right through to week 52 of the maternity leave period, or when she returns to work if that's her. For those people who are not entitled to maternity leave, so potentially agency workers, etc., the protected period is from the beginning of pregnancy until 2 weeks after the end. So employers must make sure that they and their staff, their managers, etc., don't treat an employee unfavorably on the grounds of her pregnancy or pregnancy-related illness for that matter. So some examples would be refusing to recruit a pregnant woman because simply she was pregnant, failing to protect a woman's health and safety, pregnant woman's health and safety where there are risks identified, maybe disciplining a pregnant woman or treating her less favorably because of pregnancy-related illness that occurred during the protected period, or refusing to let her have the same training opportunities, the same access to facilities, etc., as other employees. As I said, we've provided you with some resources, and part of those resources is a pregnancy timeline. So there's a load of key dates, key milestones in there to be followed by both the employer and the employee. So we're not going to cover them today, they're there for you, and hopefully you'll find those useful as well. Now, I will touch a little bit then on maternity leave.
Damon, before we go any further, we have a wee question here in the chat box. If you want to do that now, or do you want to save it to the end?
We'll save it to the end. Ruth will hang on to them all to the end. Yeah, thank you. Pregnant employees then may be entitled to take up to 52 weeks statutory maternity leave around the birth of their child. And employees automatically qualify for statutory maternity leave. It doesn't matter how long they've worked for the employer, so that's a day one. The 52-week period is made up of two parts. So we've got 26 weeks of ordinary maternity leave, weeks 1 to 26, followed by 26 weeks of additional maternity leave. And those two periods are important, and we'll talk about that later. And additional maternity leave then is weeks 27 to 50. So if an employee gives birth to a stillborn baby, she's entitled to maternity leave if the birth happens after 24 full weeks of pregnancy. If a baby was born alive at any point in a pregnancy, but then later dies, then the employee is still entitled to maternity leave. If a miscarriage occurs, and we call it a miscarriage before the end of the 24th week of pregnancy, then the employee isn't entitled to maternity leave, unfortunately. But they still might take some time off work, of course, on sick leave, or the employer could allow them some compassionate leave, some special leave, some unpaid leave, annual leave, stuff like that. An employee must take a compulsory minimum period of 2 weeks maternity leave after the birth of her child. That's extended to 4 weeks compulsory maternity leave if she works in a factory. And an employer must not allow the woman to do any work at all during that time, even working from home. And during the maternity leave period, an employer can make reasonable contact with an employee and vice versa. So the amount of contact that's reasonable will depend on whether the employee wants minimum contact or frequent contact. So it's really down to them. And it is good practice for the employer to discuss that with the woman and how they'll keep in touch and the regularity of that before she begins her maternity leave. But an employee must be kept informed of certain things during a maternity leave. So things like promotion opportunities and other information relating to her job that she would normally be made aware of. So things like organizational changes, redundancy situations, that sort of thing. And employees may, with agreement, there's a little bit of noise in the background. I'm not sure if not everybody's not mute, but I can hear something. Employees may, in agreement with their employer and on a totally voluntary basis, do up to 10 days work, known as keeping in touch or KIT days, during their maternity leave. And that doesn't affect their right to their maternity leave or their maternity pay. Now, an employee can't use a KIT day during that compulsory 2-week or 4-week maternity leave. But during their KIT days, otherwise, they can do their normal work. They could be in work, maybe attending a conference, doing some training, attending a team meeting, that sort of stuff. Any amount of work done on a KIT day counts as a KIT day, as one KIT day. So if an employee came in to work for a 2-hour training session or a 2-hour team meeting, that counts as one KIT day if that's all to do and they go back home again. And the employer and the employee should agree on how much then she'll be paid for that KIT day. That could be set out already in the contract of employment. It could be something decided on a discretionary case. But an employee can only work the KIT days if she wants to and the employer agrees to it. And an employee cannot be forced either to work a KIT day against her wishes. So doesn't have to do it if she doesn't want to do it. And it would be unlawful for an employer to treat an employee unfavorably or dismiss her because she refused to work a KIT day. The employee could go to the tribunal then for that. An employee's contract of employment continues throughout the 52 weeks of maternity leave, unless either the employer or the employee ends it or it expires, say it was a fixed term contract. But during the maternity leave, an employee has a statutory right to continue to benefit from all the terms and conditions of her employment that would have applied to her had she still been at work. The only exception really to that is to wages or salary. The employer must still pay her statutory maternity pay or enhanced contractual maternity pay if that's available. So examples of contractual terms and conditions that would still continue would be things like maybe gym membership, private healthcare, reimbursement maybe of professional subscriptions, the use of a company car, say, unless it has been specifically provided for business use only, and contractual annual leave as well. Annual leave is an important one, so it is, of course, important to us all, and an employee continues to accrue both their statutory annual leave entitlement, which is 4.6 weeks, and any additional contractual holiday entitlement on top of that. So, of course, they can't take annual leave during or while they're on maternity leave, so the employer should allow them to take that accrued leave before and or after the maternity leave period's finished. And an employee cannot be paid in lieu for any untaken statutory annual leave unless the contract's been terminated or expired and she's leaving. And unless the employee has notified her employer otherwise, then the date she returns to work will normally be the first working day after 52 weeks of maternity leave has ended. Okay. If she does wish to return early, then she's got to give 8 weeks notice before her new return date. Now, the employer has the discretion to accept less or no notice. That's absolutely fine. If an employee wishes to return to work after her planned return date, so say she planned to return at week 39, then she would need to give notice of her new date of return at least 8 weeks before the original planned return date. So 8 weeks from week 39 would be week 31. So it would. An employee who returns to work during or at the end of her ordinary maternity leave period. Okay, so we're looking here during weeks 1 to weeks 26. Well, not week 1 because we've got to take compulsory, but week 2, say to week 26. She's entitled to return to the same job on the same terms and conditions as if she had not been absent. If the employer prevents her from returning to work, she can go to the tribunal and make a complaint of unfair dismissal and sex discrimination. If she returns to work but the employer doesn't give her her old job back, she could potentially resign and claim constructive dismissal. She could raise a grievance with the employer, which could result in an industrial tribunal claim again for detrimental treatment and sex discrimination. Now, an employee who returns to work during or at the end of the additional maternity leave period, so weeks 27 to 52, is entitled to return to the same job on the same terms and conditions. However, there's a slight difference with this one. If it's not reasonably practicable for an employer to let her return to the old job, then they must offer her a job that's both suitable and appropriate for her to do in the circumstances, and on terms and conditions that are no less favourable than those of the original job. If the employee is offered a job that fulfills all that criteria and she unreasonably refuses it, then she may well have effectively resigned. If the employee is offered a job that doesn't fulfill that criteria, then she could resign and claim constructive dismissal. She could raise a grievance with the employer, which may again result in a case going to industrial tribunal for detrimental treatment and sex discrimination. The key thing for employers in this scenario in particular is they should really consult with their employee during their maternity leave period about any proposed changes to the job in preparation for the lady's return. An employer's health and safety obligations then as well when it comes to returning to work towards a breastfeeding employee are the same as they were whenever the employee was pregnant. So they must provide employees with a place to rest. And it's good practice to provide a private, clean, a safe, a hygienic room for nursing mothers to express and store breast milk as well. And toilet facilities are not suitable for that. And employees are protected from suffering a detriment or dismissal or taking or seeking to take their maternity leave. So an employer must not subject an employee to any detriment by acting or deliberately failing to act because the woman took maternity leave or sought to take maternity leave. And examples of detrimental treatment would include things like denial of promotion, denial of facilities or training opportunities, which would normally have been made available to her had she not been on maternity leave. If an employee does believe that she has been treated detrimentally under those circumstances, then again, she can take a claim of sex discrimination to an tribunal. Redundancy. If a redundancy situation arises at any stage during an employee's maternity leave, the employer may not then be able to continue employing her under her existing contract. And in those circumstances, the lady who's on maternity leave must be offered, before the contract ends, any suitable alternative vacancy before anybody else. That includes a vacancy with an associated employer or even a successor if it's a TUPE situation and there's a transfer of a company from one employer to another. The woman who's on maternity leave must be offered any suitable vacancies before anybody else. The same goes for anybody who's on shared parental leave. The same goes for anybody who's on statutory adoption leave as well. And the dismissal of an employee will be automatically unfair if she was dismissed or selected for redundancy in preference to other comparable employees, solely or mainly because she'd taken maternity leave, she'd benefited from the terms and conditions of maternity leave, or even if she'd failed to return on time from maternity leave because her employer had failed to give her the proper notification of her end date. So dismissal, selection for redundancy, or other detrimental treatment in those circumstances as well could also amount to sex discrimination. And for discrimination cases, the Industrial Tribunal compensation is uncapped. And again, as part of the resources, we've given you a maternity timeline, again with a lot of key dates, key milestones, key information in there to be followed by both the employee and the employer. And we also have an excellent publication on our website as well called Pregnancy and Maternity at Work, and you'll find some really good information in that too. I'll briefly touch on statutory maternity pay. The start date for maternity pay is normally the same date as the start date for maternity leave. So therefore, many employees will just basically say, yep, I want maternity pay to start the same time. Although there is proper notification, if for some reason the lady did want it to start later than that, or then they have to give them, the employer, 28 days notice. The lady just has to provide a MAT B1 form, so the employer can work out whether she qualifies for her maternity pay. But if she doesn't qualify, the employer then must return the MAT B1 form to her, because she will need that to try and claim maternity allowance from her local jobs benefit office. And the employer must also provide the woman with an SMP1 form as well. So statutory maternity pay is paid for 39 weeks, so it is. And to be eligible, there's some qualifying conditions, some criteria that have to be met. So the employee must be on their employer's payroll, first of all, in the qualifying week, which, as I've said, is really week 25 of the pregnancy, 15 weeks before the week of childbirth. They must give the employer the correct notice, so minimum of 28 days for maternity pay purposes. They must give proof they're pregnant, so the MAT B1 form, and they must have continuously been employed by that employer for at least 26 weeks, up to any day in the qualifying week, so up to any day in week 25 of the pregnancy. So really, when you look at your timelines, you'll see the pregnancy timeline, the employee must be employed by the employer before she's pregnant. At least a week before she's pregnant, they'll allow the 26 weeks of continuous employment. And they must also earn at least £120 a week gross in an 8-week qualifying or relevant period. And that 8-week period is the 8 weeks before the qualifying week. So really weeks 17 to 25 of the pregnancy. Now, interestingly, the meaning of the term employee for statutory maternity pay purposes is slightly different to the meaning for statutory maternity leave purposes and other employment rights as well. So that does mean that some workers, so for example, agency workers, they won't qualify for statutory maternity leave, but they may well qualify for statutory maternity pay if they meet the qualifying conditions. Okay, and for those who do not qualify, the employer, sorry, for those who do qualify, the employer pays the employee for the first weeks at a rate of 90% of their average weekly earnings. And then the next 33 weeks, so weeks 7 to 39, they're payable at the lower of either 90% of their average weekly earnings or £151.87, whatever the lower is. Okay. Then that figure is as of April 2021. That figure is reviewed annually as well, so we'll expect that to go up a pound or two in April of 2020. And of course, employers can enhance their offer of maternity pay, as many do, and they'll go over and above the statutory element to attract and to retain staff as well, and that's absolutely. I will briefly touch on shared parental leave. It's not a very well-known area. There's a very, very low uptake in the UK of shared parental leave. Only about 2% of eligible people actually take up this offer, okay? But very briefly, shared parental leave and pay was introduced back in April 2015, and that's to allow parents to share the care of their child during the first year after birth or after adoption, okay? Shared parental leave takes into account the modern family and all its different guises. So while I might refer to a mother and a father, the rights apply equally to two mothers, to a civil partnership, to parents, adopters, etc. Employees can take shared parental leave if they meet the eligibility criteria. I'm not going to cover that because there's far too much of it. And they or their partner ends their maternity leave or pay, or their adoption leave or pay early. Okay, so the remaining leave then could be taken and it would be available as shared parental leave. So for example, a mother could end her maternity leave after 12 weeks. And that would leave 40 weeks of the 52-week entitlement available as shared parental leave. And that could be shared then between the mother and the father or the partner. If both the mother and the father meet the eligibility criteria, they share that remaining 40 weeks. They can take the leave at the same time. So they could potentially take 20 weeks each then at the same time, or they could take the leave separately. Shared parental leave and shared parental pay must be taken between the baby's birth and their first birthday, or within that first year of adoption, so it can't go beyond that. And similar to maternity leave, kit days, then employees who are on shared parental leave can do some work without bringing their leave to an end. Those are called shared parental leave and touch days, or split days, and the employee can work up to 20 split days. And those are actually in addition to the 10 kit days that they could use while they're on the maternity leave element of their leave as well. So potentially somebody, maybe the woman who's on maternity and then goes on to some shared parental leave, could in theory work up to 30 keeping in touch days. Employers, some employers have already developed a policy that sets out the rules and procedures for applying for and for taking shared parental leave. It is quite a complicated area. There's some really good guidance on our website. We have also developed a sample shared parental leave policy, which can be adopted and adapted to suit the business needs as well, and that's on our website. Okay, I'm going to speak briefly now about adoption leave and pay. Again, not an awful lot known about adoption leave and pay, but it can only be taken first of all by employees. And to qualify, an employee must meet certain qualifying criteria. Now the criteria differs for UK adoptions as opposed to overseas adoptions, and also adoptions via surrogacy arrangements as well. So there's additional notification and eligibility requirements too for statutory adoption pay. So further guidance on all of that, because it's quite a complicated area. There's some really good information on the NI Business Info website and the NI Direct. I'm going to concentrate just briefly here on UK adoptions. So many of the adoption rights actually pretty much mirror maternity rights with some obvious. An employee qualifies for 52 weeks statutory adoption leave when they adopt a child in the UK if they meet, again, certain qualifying criteria. Not going to cover that, it's all on those websites. It doesn't matter, again, how long the employee has worked for the employer, that's a day one right, just like maternity leave. The statutory adoption leave period, again, is made up of like maternity leave, 26 weeks of ordinary adoption leave, followed immediately by 26 weeks of additional adoption. Employees don't have to prove that they're eligible for statutory adoption leave unless they're asked for it. However, they do need to prove and provide evidence that they are eligible for statutory adoption pay. So if the employer does ask an employee to prove their eligibility for adoption leave, then they provide them with the documentation that they were given by the. Now, the primary adopter, let's call them. So say it's somebody who's adopting on their own, or it's a couple and one person is nominated as the primary adopter. They're entitled to take paid time off for up to 5 pre-adoption appointments after being notified of a match for adoption. Okay, so they're known as pre-adoption appointments, and there's 5 of those. The secondary adopter, say if it's in a couple, a couple are jointly adopting, they'll be entitled to take unpaid time off. Okay, so unpaid time off for up to 2 pre-adoption appointments. Each of those rights are day 1 rights. However, the time off for both is capped at 6.5 hours. Okay, so it doesn't matter if it's paid time off, unpaid time off, both capped at 6.5 hours. Agency workers, they too can benefit from some pre-adoption time off. Again, they must have completed at least 12 weeks continuous service with the same employer in the same role to qualify. Now, the start date for statutory adoption pay is normally again the same as when the adoption leave starts. So normally the employee would notify the employer that they want both to start at the same time. Again, that's paid for 39 weeks, and to be eligible, the employee must meet certain qualifying conditions and criteria. And pretty much those are exactly the same, with a little nuances as maternity leave. So they must be continuously employed by their employer for at least 26 weeks. By the week they are matched with the child. Okay, so slightly different from maternity. 26 weeks by the week that they've been matched with the child. They must again earn on average at least £120 a week gross in a relevant 8-week period. And again, that's the 8-week period before they were matched with the child. They've got to give the correct notice, so minimum of 28 days notice for their statutory adoption pay, and they must give proof of the adoption paperwork, etc. Again, similar to maternity pay, the meaning of the term employee for the purposes of adoption pay pretty much mirrors the meaning for adoption for maternity pay. So that does mean that some workers, like agency workers, they're not employees that don't qualify for adoption leave, but they may qualify for adoption pay. And again, some employees who don't qualify for adoption pay because they don't quite meet all the criteria, or maybe the service element of it, the employer must provide them with an SAP1 form. Now, there's no equivalent to maternity allowance for adoption. Okay, so an employee would need to speak to the local jobs and benefits office, the local authority, to find out if they're eligible for any other types of payments. For those who do qualify for statutory adoption pay, then the pay is exactly the same as what I've discussed already for statutory maternity pay, no difference. And again, employers can pay enhanced adoption pay if that's. Again, during the adoption leave period, an employer can make reasonable contact with the employee and vice versa. And again, the employee must be kept informed of promotion opportunities and other important information like reorganization, like redundancy. Employees, again, may totally voluntarily and in agreement with their employer do up to 10 keeping in touch days, 10 KIP days under the contract of employment without that affecting their leave and their pay. And exactly the same rules again apply as with maternity leave. And again, it would be unlawful of the employer to treat an employee unfairly or dismiss them or anything because they refused to work a KIP day while they were on their adoption leave. And just like maternity leave, excuse me, during the entire statutory adoption leave period, the employee has a statutory right to continue to benefit from all the terms and conditions of employment. Again, the only exceptions are terms relating to pay, salary or wages. But again, the employer is still obliged to pay them their statutory adoption pay if they're eligible. And exactly the same provisions apply as maternity leave when it comes to the accrual of annual leave, adoption leave, etc. And again, unless the employee has notified the employer otherwise, the normal date of return to work would be the first working day, 52 weeks after the statutory adoption leave period began. Exactly the same rules apply when it comes to returning to work early. You've got to give at least 8 weeks notice. And if they wish to return after their planned return date, then they've got to give 8 weeks notice before the original planned return date. And an employee who returns to work again during or at the end of the ordinary adoption leave period, so up to week 26, is entitled to return to exactly the same job on exactly the same terms and conditions as if she'd not been absent. Same when it comes to the additional adoption leave period, they're entitled to return to the same job on the same terms and conditions. However, if it's not reasonably practicable for the employer to let her do that, then she must be offered a job that is both suitable and appropriate to do in the circumstances, and on terms and conditions that are no less favourable than those of the original job. And if the employee is offered a job that fulfills that criteria and turns it down, then potentially they may well have effectively resigned. If the employee is offered a job that doesn't fulfill that criteria, exactly the same as maternity, then they could potentially resign, claim constructive dismissal, they could raise a grievance, and potentially go to the tribunal for detrimental. And again, no different from maternity leave, the employer really should be consulting and communicating with the employee during their adoption leave if there are going to be any proposed changes to the job in preparation for that. And again, employees are protected from suffering a detriment or dismissal for taking or seeking to take their adoption leave. So they should not be subject to any detrimental treatment because they did that. And if the employee believes that they are being treated detrimentally, then they can resign and claim constructive dismissal. They can raise a grievance, potentially go to tribunal for detrimental treatment if the employer fails to address the grievance properly. And if a redundancy situation arises, I've said it already, then they must be offered, just like maternity leave, just like shared parental leave, they must be offered before anybody else any suitable alternative vacancy. So that's a protection that people have around maternity leave, shared parental leave, or adoption leave. Okay. Let's move on then. We'll look at paternity leave and pay very briefly. So paternity leave and pay is available to an employee who is the father of a newborn child, or the spouse or partner of either a woman who has given birth, or who is adopting a child, or is having a baby through a surrogacy arrangement. If the circumstances apply, then women too can be entitled to paternity leave and pay, given the way the law is now framed for partners. However, to qualify for both paternity leave and pay, the employee must first meet, again, certain qualifying criteria. Different qualifying conditions apply to paternity leave requests relating to births, to adoptions, or to surrogacy arrangements. They're slightly different. And again, there's really good detailed information and guidance for trade union reps, for employers, for employees on NI Business Info in particular. I'm going to concentrate just briefly on paternity leave related to births. So the employee should notify their employer no later than the end of the 15th week before the expected week of childbirth, i.e. week 25 of the pregnancy, or as soon as is reasonably practical of the expected week of childbirth, whether they wish to take 1 or 2 consecutive weeks paternity leave, and when they want their paternity leave to start. Eligible employees can choose to take a single block of either 1 or 2 weeks paternity leave. Okay, so the maximum entitlement is to 2 weeks. They cannot take it as odd days. They cannot take it as 2 separate weeks. It must be a block, unless the contract permits otherwise. So the employer could be more generous and allow them to take it separately. The amount of time off is the same even if the pregnancy results in multiple births. So if there's twins, they still get the same amount of time off. It's no different. And an employee can only take paternity leave to care for the child and or support the mother, not for any other reasons. So they shouldn't be taking paternity leave and going off and doing another job somewhere. An employee cannot start their paternity leave until the birth of the baby. Otherwise, they can choose to start their leave on the actual date of the baby's birth, whether that's earlier or later than expected. They can choose to start it on a specified date, as the employee has notified the employer of, falling after the expected date of birth. So they could say, baby's due to be born on the 1st of February. I want to start my paternity leave on 5th of February. And as long as the baby's been born, then there's no issues with that whatsoever. Paternity leave can start on any day of the week, and it must finish really within 56 days of the actual birth date. During paternity leave, an employee has the statutory right again to continue to benefit from all the terms and conditions of employment, which would have applied to them, again, except for wages or salary. And again, the employer is obliged to pay them their statutory paternity pay. The employee again continues to accrue their statutory and any contractual annual leave throughout that little period of paternity. And on direct return from paternity leave only, then the employee is entitled to return to the same job on the same employment if they've not been absent. Employees again are protected from suffering a detriment or dismissal for taking or for seeking to take paternity leave. An employer must not subject an employee to any detrimental treatment by acting or by deliberately failing to act because the person took paternity leave or wanted to take paternity leave. And again, examples of that type of treatment can be denial of promotion, denial of facilities, training opportunities, etc. If the employee does believe they've been treated detrimentally for those reasons, then they can raise a grievance with the employer. And potentially, yeah, absolutely, they could go to the industrial tribunal and claim for detrimental treatment if the employer has failed to address it satisfactorily. So the employer must not dismiss an employee because they took paternity leave. They must not select them for redundancy because they took paternity leave. They must not prevent an employee returning to work after their paternity leave. And again, if an employee is dismissed in those sort of circumstances, they can take a complaint to the tribunal. Regardless of their length of service, they don't have to have the 1-year minimum service. If a redundancy situation arises at the time of the paternity leave, then the employer treats them the same as any other employee in those circumstances. So there's no special protection for anybody who's on paternity leave. So they would still need to consult them about the redundancy and still need to consider them for any other suitable job vacancies, but they don't have the entitlement to be offered any suitable alternative vacancies before anyone else. Statutory paternity pay. I think I covered that, sorry, I've lost my place. Apologies. There you go. To qualify for statutory paternity pay, then the employee has to meet, again, certain qualifying conditions. That includes being employed for 26 weeks by week 25 of the pregnancy and earning, again, an average of £120 per week gross in that relevant 8-week period week 17 to 25 pregnancy. Statutory paternity pay again is exactly the same as statutory maternity pay and statutory adoption pay. And the same meaning when it comes to the word employee. For statutory paternity pay purposes, that's exactly the same as maternity pay and adoption pay. So you could find that an agency worker may qualify for statutory paternity pay, even though they don't qualify for the paternity leave. If you don't qualify, if an employee doesn't qualify for the pay, then the employer has to give them Form SPP1. Again, there's no equivalent to maternity allowance either. So there's not, so they'd have to speak to the local job and benefits office, see if they would be eligible for any type of payment. And that's basically paternity leave covered. Now we'll move on to parental leave. Not to be confused with shared parental leave, this is a different thing. So this is statutory parental leave. And employees with children who are under the age of 18 years of age are entitled to take periods of unpaid statutory parental leave. Parental leave cannot be transferred between parents, okay? And it isn't to be confused, like I say, with the shared parental leave. It is different. So an employee must qualify again, must comply with certain criteria, and also notification requirements before they can take their leave. And one of the key requirements is that an employee must have at least 1 year's continuous service with their employer at the time the leave is to start. So if they qualify, then the employee is entitled to take up to 18 weeks of unpaid parental leave per child between birth and their 18th birth, the child's 18th birthday. So that's 18 weeks across those 18 years. Each parent's entitled to it. So potentially, you know, for a mom and a dad, that could be up to 36 weeks of unpaid parental leave across the child's first 18 years. They can't, as I said, transfer that. So one can't say, I'll take 10 and you can have the other 26. It's 18 weeks each. The parent doesn't have to live with the child to qualify either. And an employee must give at least 21 days notice before a period of parental leave can start. And that would be, they've got to give notice of the start date and the end date. Now, if the business has really good business reasons, then an employer can postpone the leave, and they can postpone it for up to 6 months from the original date that was requested. However, an employer can't postpone leave if it ends after a child's 18th birthday. It must be taken before then. And an employer is really only entitled to postpone the leave if it would cause really significant disruption to the business. So I suppose some examples of that could be if a leave was requested over a very significant period of, of peak seasonal business, say, maybe the same time as lots of other employees have requested time off, when the employee's absence would maybe unduly harm the business in some way, or where maybe a replacement cannot be found within the notice period. An employer can't postpone the leave where the employee wants to take it immediately after their child is born or placed with them for adoption. So they can't do that either. And if an employer does need to postpone the parental leave, then they must consult with the employee about a new start date. And to do this, they must write to the employee within 7 days of receiving their notification, first of all, their request, and explain to them why they need to postpone it, and offer some suggested new start and end dates as well. Employees can take up to a maximum of 4 weeks leave in any year. And obviously that would leave them less for future years in respect of any individual child. So if you have 2 children, 3 children under the age of 18, you could potentially take 2 times 4, 3 times 4, Of course, it's unpaid, unless the employer allows them to take more. So that's the default position, maximum 4 weeks in any year. The employer could potentially allow them to take more if they want. Periods of leave must be taken in multiples of 1 week. Cannot be taken in shorter blocks unless the employer agrees, or unless the child is disabled. So it's a wee disabled child, in which case the leave can be taken as individual days, and that's the statutory entitlement. The employment contract again continues during any period of parental leave, and continuous service isn't broken. The leave is unpaid, as I've said numerous times, unless the employer does wish to offer pay. And an employee continues to accrue their statutory holiday entitlement during their unpaid parental leave. Whether or not they would continue to accrue their contractual element of any paid holiday entitlement would depend very much on the contract. And some terms and conditions of employment continue to apply during parental leave. So this is, again, a mandatory thing. So things like notice requirements, redundancy entitlements, disciplinary and grievance procedures, they would continue to apply during any period of unpaid parental leave. Again, some really good information on the NI Business Info website. Whether or not other contractual terms and conditions continue to apply, again, things like access to a company car, maybe some perks like gym membership, healthcare, that sort of stuff. That again will depend on the contract of employment. And an employer again must not subject an employee to any detrimental treatment for taking the parental leave or seeking to take it. They mustn't dismiss an employee or select them for redundancy because they took or they sought to take their parental leave. And if the employee does believe they've been treated in that way, they can again go to the tribunal with a claim for detrimental treatment, unfair dismissal, that sort of stuff, again, regardless of their length of service. With regard to redundancy, if an employee is on unpaid parental leave and a redundancy situation occurs, then they're treated in exactly the same way as any other employee. There's no special protection. And an employee is entitled to return to the same job as before if the parental leave was for an isolated period of 4 weeks or less. Okay. They're also entitled to return to the same job if the period of parental leave was for 4 weeks or less and followed by a combination of either maternity, adoption, paternity, or shared parental leave of 26 weeks or less. So it starts getting complicated. If the period of parental leave happened to be for longer than 4 weeks, so if the employer did allow more than 4 weeks, or was preceded or followed by a period of maternity, adoption, paternity, or shared parental leave of more than 26 weeks, then the employee is entitled to return to the same job as before, but only if it's reasonably practicable for the employer to do that. Again, if it's not similar to maternity, etc., then they're entitled to return to a similar job that's suitable for them to do on the same or no less favorable. So these things start to get a little bit complicated whenever we're talking about returning to work in some cases. Now, time off for dependents, again, not a very well known right, but all employees have the right to a reasonable amount of unpaid time off to deal with an emergency involving a dependent. That's a day one right. Okay, so employees do not have to complete any type of qualifying period in order to take time off in an emergency situation. The right does not include an entitlement to pay. So whether or not the employee would be paid is a matter for the employer and the contract. Who's a dependent? Well, a dependent is a spouse, a partner, a child, or a parent, or someone who lives with the employee. It doesn't include tenants, lodgers, boarders. It doesn't include an employee who's living in the household, such as a housekeeper, an au pair, a nanny, that sort of thing. A dependent could also be someone else who reasonably relies on the employee for care. So that could be an elderly relative, an elderly neighbour, something like that. Employees can take the leave when a dependent falls ill or is injured or assaulted, and that includes mental illness or injury. So emotional distress, that sort of stuff. And they can also take it if a dependent goes into labour. They can also take the leave when they need to for making longer term arrangements for a dependent who is ill or injured, to arrange or attend a dependent's funeral, to deal with an unexpected problem in care arrangements. So a typical example of that might be a childminder who's unexpectedly unavailable, or to deal with an incident, say, involving the employee's child during school hours. If there was a major incident of assault or suspension, that sort of thing from school. The right is to, as with a lot of these rights, is to reasonable time off. Doesn't specify in the law what is reasonable, but the amount of time off isn't fixed. So it's really about allowing the employee to deal with the immediate problem and then to put the other necessary, say, care arrangements, etc. into place. So for example, an employee wouldn't normally be able to take 2 weeks off to care for a sick child. They could take maybe a day or 2 or 3 in the initial stages, take the child to the doctor, etc., and arrange then for longer term care. And an employer must not again subject an employee to detrimental treatment for taking that time off, or dismiss them or select them for redundancy for taking that time off, or for seeking to take that time off. And again, if the employee believes that they are being treated in that way, they could take a claim of detrimental treatment or unfair dismissal to the tribunal, regardless again of their length of service. Okay, and then finally, briefly touch on flexible working. Now, an employee has the statutory right to make a flexible working request, and there's some qualifying conditions for that. So they must have worked for their employer for at least 26 weeks continuously, and they must not have made another statutory request within the past 12 months to the employer. So the statutory right is a right to request flexible working. It's not a right to be granted flexible working. The right is open to all employees who meet the eligibility requirements. So it's not restricted to parents or the carers as it once was. And the term flexible working covers flexibility in terms of the hours that are worked and the location as well. So it covers things like compressed hours, part-time working, job sharing, remote or home working, hybrid working, career breaks, sabbaticals, that sort of stuff, term time work. So it can cover a lot of different angles. I'm going to run through some of the basic rights and responsibilities, first of all, of employees. So employees have the right to apply to work flexibly. They have the right to have their application considered properly in accordance with the set down procedures, and refused only if there's a clear business ground or business grounds for doing so. They have a right to be accompanied by a work colleague when meeting the employer to discuss the application. And they have a right where an application is refused to have a written explanation explaining why it's been refused. They have a right to appeal against the employer's decision to refuse their application. And they have a right to take a complaint to an industrial tribunal or to our arbitration scheme in certain circumstances too. And they have a right to be protected from detriment or from dismissal for making the application. So again, they're protected because they've made an application, they've exercised the right under flexible working to request that. They've made a complaint to an industrial tribunal in respect of a flexible working application, they're protected against that too. They've protected if they've exercised the right to be accompanied to the meeting. There's a lot of protections in place in case the employer did treat them detrimentally. But employees also have some responsibilities. So they need to provide a carefully thought out application. The onus is very much on the employee to provide as much detail as possible. The responsibility there as well to ensure their application is valid by checking that they've met all the eligibility criteria, and also to ensure the application is made well in advance of when they want it to take effect. The process can take 12 weeks, 14 weeks. It'll take potentially up to 14 weeks if the employer asks for a little extension to be able to make their decision. Generally 12 weeks minimum anyway. They'll have to make sure that the application's in well in advance of when they want it to take effect. And I suppose they have to be prepared to discuss their application in an open and a constructive manner as well. And if necessary, maybe they need to be prepared to be flexible themselves in order to reach an agreement with the employer. From an employer's point of view, then from a rights point of view, they do have a right to reject an application when the desired working pattern genuinely accommodated within the needs of the business. They can seek the employee's agreement to extend the timescales where it's appropriate by up to 2 weeks. And they can consider an application withdrawn in certain circumstances too, if the employee doesn't come back within certain timescales. But employers have responsibilities as well. So they need to consider requests properly and in accordance with the set down procedures. They need to ensure that they adhere to the time limits that are contained within the procedures. They need to provide the employee with appropriate support and information during the course of their application. They can decline a request only where there are specific business grounds. And the law, the Employment Rights Order, specifies those grounds as well. And they need to explain to the employee in writing why those grounds apply. They need to ensure that any variation from the procedure is agreed with the employee and recorded in writing, so extensions and things like that. And they need to ensure that they do not subject the employee to any detrimental treatment or dismissal for making an application under their right as well. Again, quite a complex area, lots of information there. Some really good details and guidance on flexible working and the application process on our website, and 2 really good documents. One is called Flexible Working, the Right to Request and the Duty to Consider. And the other is Flexible Working, the Law and Good Practice. So those are on our website, by all means. You can go on there and have a wee look. Sources of help, I've mentioned lots already, so I have. It just gives you some further details there. Our workplace information service, so our helplines there, Monday to Friday, 9 to 5. Our website address is there. Equality Commission as well for any of the equality or discrimination sides of things. NI Business Info, really excellent website, some really good stuff on that. And NI Direct, maybe to a lesser extent there as well. Okay, that as a whistle-stop tour brings us to the end of the presentation side of things. I know there's probably maybe some questions in the chat function, so